Now, hi everybody. I was going to say New Zealand is now right in the middle of copyright reform, but that would not be true. The ministry started at the beginning of last year, but these things can take some years, so we're probably nowhere near the middle yet. And so I'm going to deal with some of the topics that are up for grabs in the reform process. We can't do the whole lot anyway. So this is my selection. And I do have to say though, and for those who perhaps haven't been familiar with the firm's activity on this matter, AJ Park has already made submissions to MB, and we'll have more opportunities to make submissions as things proceed along the way. Now, let's get to the contents of today's session. And those are the topics I'm going to talk about. And you'll actually find there's quite a big chunk on copyright issues surrounding streaming, whether they be audio streaming or video streaming. And I particularly mention those not just because it's a complicated issue that needs to be properly sorted out in a new act, but also I think the New Zealand courts so far in that area have been going wrong. So I should say that the first and last topics on that screen, I could say I'm going to talk about fair dealing in relation to a bit of gossip, and I'm going to finish with artificial intelligence by reference to spiritual seance. So hopefully you might find that a bit amusing when we get to that. Well, here's the gossip in relation to fair dealing. And you can see Meghan Markle there, photograph with her father. And you can see that reproduction, start of a letter which she wrote to her father in 2018. Unfortunately for Meghan, her father got this to the UK newspaper Mail on Sunday through an intermediary. He wanted it published because he wasn't really sort of very nice to his daughter at that time. Who knows what he's like now, I'm not sure. But anyway, that was published, not just reproductions of the text of her own handwriting, but also the normal sort of journalistic comment and so forth on it. And not surprisingly, it upset her and Prince Harry. So obviously the legal advisor said they had a number of causes of action, but one of them is copyright, and that's the only one we're going to deal with today. And although it surprises some lay people that I've spoken to about this, naturally, her letter to her father, personal and private, is nevertheless a literary work, and therefore copyright exists in that. She's the author, so she owns that copyright. So suing for infringement of copyright is one cause of action she's got against the gossip rag. And the infringing action, I've said out there, issuing copies of work to the public. That's the infringement provisions, and I've listed the UK one, the New Zealand one, virtually the same as the UK. Now, what defences might Sunday Mail on Sunday have? And the one no doubt we'll be going for is this fair dealing provision in the UK Act, and we have it in our Act as well. Fair dealing with a work for the purposes of reporting current events does not infringe, provided you sufficiently acknowledge the owner of the copyright. Now, is that likely to be successful? Well, The first thing the court's done in the past on this is they consider, well, is it fair in the first place what has happened? And in fact, Associated Newspapers, who own the rag we're talking about now, was sued in 2006 by Prince Charles. They seem to have forgotten that, and they published his private diaries that he made whenever he did overseas visits as the Queen's son. These are all official visits, but as well as the official reports that went back home, he also kept diaries of his private thoughts on the various presidents of different countries that he met. And the Mail on Sunday went and published those. An employee of Prince Charles got the impression she was likely to be sacked soon, so she photocopied his diaries, and then when she was sacked, she gave them to the Mail on Sunday, who published them, of course. They lost the first case in the High Court. They appealed, but the Court of Appeal said that they didn't even get a starter on the fair dealing provision because what they did was simply not fair. They published something which was private. Well, Meghan's case is going to be even stronger because her letter was not only private, but also very personal and totally unconnected with any official duties whatsoever. And I think that that defence is certainly not going to work. Now, you might have read in the paper a week or so ago about the interlocutory hearing on Meghan's case, and a couple of causes of action were modified or thrown out, but copyright, I can assure you, is still very firmly there, as is breach of privacy. Well, some people, even in New Zealand, have been advocating perhaps we get rid of fair dealing, and fair dealing provisions around the world is where the Copyright Act actually sets out in black and white the exceptions to copyright infringement, as opposed to the other way of handling it like America does, have a fair use doctrine, which has been a case law sort of established thing and doesn't have everything specifically laid out in the Act as to when it works and when it doesn't work. And some people in America call it an equitable rule of reason. Oh, and I should have mentioned, and Matt and I and AJ Park are pretty firm on this, if we're going to stick with our fair dealing, we need to put in another exception for parody, satire and parody. So that's in the AJ Park submissions. But this equitable rule of reason, yeah, pure case law in the US. But then we have Professor Goldstein, noted US and international copyright lawyer, who says no copyright doctrine is less determinate than fair use. So you never know whether it's going to work or not if you're using it as a defence, and so you could almost toss a coin, which leads to a lot of litigation concerning fair dealing. And we can say, well, that's good for us. We make money out of that if we had fair dealing here, but it's certainly not good for clients. And it's got even more difficult as we're moving into the copyright and into technology, computer software, for example. And this is a big case which has been grinding on in the US, and the courts seem to struggle to understand what they're talking about. This is where Oracle is suing Google. It's finally now got the Supreme Court, and officially it was supposed to, actually the hearing in the Supreme Court was supposed to start last week, but I don't know that it has, or perhaps the virus has stopped it. Right, next topic, expression versus ideas. Does copyright protect both? Well, classically, it protects only the expression of ideas and not the ideas per se. But unfortunately, in the UK, for quite a long time, the courts there did allow a partial protection of ideas under copyright. Now, with a bit of pressure on them from Europe, they've sort of changed their mind there, and also reread the TRIPS Treaty, and there's a provision in the TRIPS Treaty, of course we're signatories to. Copyright protection shall extend to expressions, not to ideas, procedures, methods of operation, or mathematical concepts as such. Well, despite us signing up in 1994, we never put it in our 1994 Copyright Act. Who knows why? I don't know why. But in the case that I was heavily involved in, the Karam and Fisher and Paykel Finance case, software copyright case, both the Court of Appeal and the High Court said no copyright in ideas and referred to TRIPS, despite the fact there's nothing in our Act. So they adopted the treaty directly. Now, that's all very fine, and we've got, but who knows? The Supreme Court often seems not to always follow the Court of Appeal, particularly when it comes to copyright. So we really should put this provision in our Act. Easy peasy one. Shouldn't be any debate whatsoever on this. Who knows why they never put it in years ago. Well, that's a quick topic out of the way. Now, some more difficult issues that relate to sort of keeping copyright law up to date with technology, and of course we mean information technology. Don't need to look at that diagram. It's just emphasising we're getting into technology. Move on from that. But before we sort of look at copyright application to information technology issues, just to review the most relevant rights under copyright for this area. And the first one is the communication right, as it's known. And that was put together by Copyright Treaty back in 1996. And we only got round to putting that in our Act in 2008. And so they're looking at the sole right to communicate a work, which of course only the copyright owners got that unless they've licensed it. And what it really amounted to was broadening the exclusive right to broadcast a work. Broadcast, getting a bit old-fashioned, just radio and television, and not covering the internet. So to cover communication over the internet of a work was what was aimed at. Now, I just mentioned a bit of an oddity here in the US, who say that they certainly have a communication right, but you'd struggle to find it over in the US because they consider it's just one of the subcategories of the exclusive right to perform a work. When you think performance, you think of a band on a stage or something, and what the devil has that got to do with communication? The other funny thing is that it's never been applied to broadcasting sound recordings. Radio stations never had to pay recording companies in the US, and even if they've been going over the internet, if they go over the internet, because that's digital, they do have to pay a license fee, but old radio stations still don't have to pay one. A little bit strange, opposite to New Zealand. A European Union oddity, they have held that the communications right is infringed by someone who sells communications equipment, which is a little bit odd in my view, and we'll cover a bit more of that soon. Now, next right, important right, the reproduction right. And it's expressed in our Act as exclusive right to copy the work. But then when you look up the definition of copying in Section 2, it sets it out. It means reproducing, recording, storing the work in any material form, including any digital format, in any medium by any means. So pretty broad sort of concept. and yeah, it covers downloads onto a disk, for example. But what isn't specifically in our Act, but it's in the Berne Convention, reproduction includes temporary and transient reproductions, not just permanent or semi-permanent ones. And it presents some difficulties when we come to things like streaming over the internet, which we're going to get into soon. And so, but also, transient is sort of a word for meaning a very short, tiny period of time. Temporary sort of, well, not permanent, but a bit longer period of time. And it's been held in some countries that browsing a web page, that's a temporary reproduction. It might be sitting on the screen for a few minutes or something, but more than half a second. And then, as I mentioned, receiving audio and video streams, that's transient reproduction, which is necessary at the receiving end, and I'll get into that shortly. And internet service providers sometimes cache web pages to make it faster for those of us in Auckland or Wellington to sort of access something that's in the US. And then also retransmitting the work, say picking up a broadcast and then retransmitting it as a stream. That involves reproduction as well. And before we get into streaming, we have in New Zealand communication works, and nobody else does. Australia doesn't. And the communication work means a transmission of sounds, transmission of visual images, or combination. And it's come about because we've always said that a broadcast is a copyright work in the past. So we broadened it and called it a communication work because a lot of stuff that goes over the internet is not directly analogous to a broadcast. Oops. I don't know whether that came up for a second anyway. And we're a bit unique. Where did that go?
Yeah, just go back into the screen share. It looked like something popped up on your laptop at the time.
Yeah.
So click the screen share button down the bottom.
Oh, there we are, yeah. Right.
Yep.
Yeah, right. So this signal copyright, as I call it, copyright in a signal is different from the copyright in the content, which is in the signal, and we've always got to keep that in mind. And of course, when I say we're unique, classic one who doesn't have this is Australia across the ditch. So that means there's no, while there's a copyright in a broadcast over there, there's no copyright in a modern stream in Australia. So maybe they've got that one wrong. Now we get into streaming, and you know, the big distinction when it particularly comes to copyright is we're not talking in any way about something like a download or file sharing, you know, which those things, it's like sort of a bath by analogy. You know, content sits there, fed into the bath and sits in there. As opposed to streaming, the analogy is more with a shower. You know, the content comes in and then goes out. And with streaming, of course, that's what we have. Content comes in, digitized, and then is deleted and not stored like a bath. Now, just sort of going backwards a moment in terms of videos. Way back, the only way people could watch at home a movie was to have their own movie projector. They were expensive, not too many people had them. But would you think that people running a movie projector and watching the reproduction on a screen would infringe copyright? And no, that was obvious to everybody, including even lawyers. What about this? Watching television, could that infringe copyright? No, obviously not. Everyone said no. So why is it when we're watching, say, stream video, and there's just one brand really there, should that infringe copyright? Well, courts have been saying yes, it does, despite the fact that old movies and television watchings did not. So they're going a bit nuts, in my view. Let's see what the issue here is. You know, we've got data packets representing video content being received off the internet, and you've got to have to receive them a set-top box, which can then feed pictures to the TV set. And so the set-top box has somehow got to assemble all the packets of data representing the content into frames to put successive frames up on the TV set. You know, it's funny that TV uses the frame technology like movies does, one frame after another. TV's always used that as well. Well, what does a set-top box do? Well, one of the things it's got to do is, as each data packet comes in, store it until it's got 50 in a row, because there are 50 of them make up the content of a picture frame. So the packets of data are all coming into the buffer memory until it's nearly full. There we are, we've got 49. And then the last one comes in, right, it knows I've now got a frame. Of course, it's got to convert that into a video signal that the TV set can see. But it does that, and one frame appears on the screen. And in theory, the packets are only sitting in that buffer memory, packets of data, for 0.04 seconds. And then they're deleted. In fact, you may store more than that, and that means holding them for a bit more than 0.04, but nevertheless, only for a tiny amount of storage. And oops, delete, and then the next slot come in for the next frame. Well, there is transient storage there. So infringement, in theory, under our copyright law. But there is a fair dealing exception for transient copying, section 43A. And there are the words coming up there of the section. So no infringement if reproduction is transient and is an integral and essential part of the technological process for either making or receiving a communication that does not infringe, or enabling the lawful use of the work. Well, unfortunately, the courts have got a bit confused on that and have often combined B1 and B2 and haven't realised that if you're ticking off what's happening in an action that comes to your court, you've got to look at one at a time. Okay, ooh, this communication, yeah, that is infringing, but you don't just say, right, we can't use this fair dealing provision. We've got to look at the second one, enabling the lawful use of. Well, even with old movies, if someone had a movie film which was an infringement of somebody else's work, it wasn't unlawful for them to play it on their home screen to show the kids. It was still a lawful use. Well, unfortunately, our courts have been not treating streaming in the same sort of way and have been holding that Section 43A doesn't apply in a number of cases. Now, some of the streaming cases we've had in New Zealand, a couple in the High Court, one in the District Court, and you see two of them is actually Sky Network. And in the Sky cases, the exception for transient reproduction is something that's been considered, what we've just been talking about, but also communicating a work has been an issue that's arisen as well. And in the Sky cases, they were suing a supplier of set-top boxes, which effectively were programmed to receive infringing streams from offshore servers, we call them pirate servers, for example. And in the case, in the facts that they were using in these cases, Sky was pointing to game of cricket in New Zealand, test match, which through legal reasons, the feed was taken right back to the UK Sky, and they had the license to broadcast it in the UK. These pirate streamers, or a pirate streamer, was picking up that broadcast signal, putting it over the internet as a stream, so that there could be people in New Zealand who paid nothing, but didn't even have subscriptions to the pirates. They could watch free and didn't need to pay a Sky subscription to see it. And Sky New Zealand had the license to show in New Zealand. So Sky was upset, as you can well imagine. And they took a Fair Trading Act claim against the importer and seller of the set-top boxes, because they had noted that the importer was saying it's quite legal to use this for these purposes. And they said, no, that's a breach of the Fair Trading Act. And then of course they had to explain why it was a breach. And to do that in court, they had to show that what was happening was that the recipient was infringing the copyright in the signal. And so that's mostly what the cases, Sky cases, were about. Well, that's just repeating what I've said already. Let's go to the next slide. Get the first weird decision out of the way. Judges were finding that communicating the works to the public, that right was infringed by selling set-top boxes. And they were applying the Court of Justice of the European Union's interpretation that said that communication to the public included the sale of set-top boxes. But when you actually look at the definition of communicating, you know, and applied normal common law statutory interpretation, you know, how do you say transmit information is the same as a bit of equipment, which might be one of the bits of equipment involved in having it transmitted, or in this case only received. All of this communication right came from the WIPO Copyright Treaty in 1996, and all of their notes and writings and in the treating said it was just transmissions. So why Europe decided to go beyond transmissions and then get followed by our courts, I do not know. Well, now in these cases, the defence of transient reproduction, and this is where Justice Potter amalgamated the two legs of the Section 43A defence and said it was an infringing work, and that was all. That was start and finish of it. The exception couldn't be applied. And then in the Sky case, and the one in the High Court, said Section 43A did not apply because it was not and is not lawful for the consumers to receive. So this is the other limb, not just the one about whether the transmission was an infringement. They said it was not lawful to use boxes to receive that sort of material. Well, where the devil that came from, I do not know, because as we've seen with watching television, normal, standard old-fashioned television, not streamed material, or watching old movies, it was always lawful for people to receive and view that material. Well, before the Sky cases, there was a case in the UK Supreme Court, meltwater case as they call it, and they said it was lawful for somebody to watch on a screen. There's no legislation, including the Copyright Act, stopped that. So, you know, watching, not a problem. The transient reproduction exception must apply. So that was the case in the UK. We went the opposite way around. And yeah, as Lord Sumption said, it's lawful if its use is not contrary to statute, and viewing not an infringement in the UK nor in New Zealand. Different story if you're actually showing to the public in some circumstances, and where perhaps you've demanded payment from the public to come and watch it. That's unlawful, but not for home consumers. And amazingly enough, the Court of Justice of the European Union was happy with that, even if they went in the opposite direction when it came to the right to communicate. Well, you can feel sympathy for Sky. So even if things just stayed as they were case law-wise, is there another way in which they could put a stop to New Zealanders receiving illicit streams? Well, in the UK, that has been done by virtue of obtaining a blocking order in the courts against internet service providers, requiring them to block access to the IP addresses of the streaming server, the pirate server. And of course, Matt Hayes and I have been pretty strong on this issue here, and certainly believe that our courts, the High Court, would have an inherent jurisdiction to do that, even though there's no reference to blocking orders in our Copyright Act. But better to not only have blocking order provisions in our Act, but to clarify the current transient reproduction exception, which the courts seem to be stumbling over. But again, yeah, having blocking orders available will be very useful. Sure, Sky will be very happy then. Now, in Australia, they do have blocking orders. They put it in the Act only a couple of years ago, and they've already had a case. And this is where on YouTube, many companies to promote, say, new record productions and so forth, would allow people to test them out by streaming them and listening to them. And unfortunately, people around the world decided we could, if someone wanted to, we could convert that stream file down to a download, and then we could sell it to them, and they could actually have a proper download and sitting on their computer to play whenever they wanted. Well, of course, the recording companies weren't too happy about that. And anyway, the Federal Court in Australia said this infringed the music and sound recording copyrights, and therefore granted blocking injunctions. And there's some of the ISPs that they no, sorry, some of the pirate sites that they had the ISPs block. So, you know, the Aussies got that one right. Now, there's another defence against music streaming. I don't think it's been argued anywhere, but it's certainly something I'd be pushing. And, you know, for there to be infringement, the whole or a substantial part of a work must be copied. So if you're looking at the transient storage of little data packets coming into the buffer memory of any sort of input box system, you have to realize that what's actually stored in the buffer memory before it's deleted may only amount to half a musical chord. Now, can you say that constitutes a substantial part of a musical work? I don't think any court would say that. So I think recipients of music streams have got another way to defend themselves if necessary. But unfortunately, that's not a substantial part defence. Doesn't help you for video, because the Act specifically says that just copying one frame of a video, or let alone a movie, is infringement. Right, last topic, works created by artificial intelligence. And although there hasn't been much discussion in New Zealand on that, there is a lot of discussion in other jurisdictions, has been for about 2 years, because we're not just talking about self-driving cars, the artificial intelligence looking after that. We're talking about artificial intelligence that's been set up to compose music, compose lyrics. And all you have to do is say, you know, I want a music that sort of has these characteristics, and lyrics that sort of follow this theme. Feed that into the system, and there's so many algorithms in there, and so much data. Just about every recorded piece of music is sitting in there, and the artificial intelligence just can work through all this, pulling bits together and assemble out of bits of music, even if they're just notes, bars from other bits and pieces, put the whole thing together and fire it back to the person wanting that piece of music. Quite amazing. Now, we do in New Zealand provide copyright for computer generated works and say that, well, the owner is going to be whoever made the arrangements for the creation of the work. But using artificial intelligence as it is now, so sophisticated to create new music, there's no one that's really making arrangements. It just, system does it itself. So what are we going to do? Should there be copyright there? Or should there not be any copyright? Should anyone just be able to rip off that sort of music? And that's what a lot of countries are now considering. Now, is there any useful case law precedents already that might give us an answer? Well, what about, you reckon there's a similarity between our artificial intelligence, and there we've got one there, to a spirit? And just like the artificial intelligence, the spirit is not actually alive. We've got a lady there who's receiving something from the spirit, and no doubt telling the people that are with her in the seance. Well, there's actually been a few cases in the UK and the USA some years back on who owns, or is the copyright, and if so, who owns it, on words that have been uttered by spirits at seances. And this is a British case in 1926. But one lady who was at the seance was writing down everything that the spirit said. And then that got published and a copyright issue arose. Well, like, who's the author? Who owns it? Well, back in those days, the standard for originality was even lower than it is now. And people who were stenographers were joint authors of whatever utterances were written down. And in that particular case, Cummins and Bond, it was held that the lady who wrote it down was a joint owner of the copyright and therefore could assert that copyright, even if the other joint owner of the spirit didn't happen to be around. Yeah, well, with higher tests for originality, stenographers wouldn't be owners, and that would only leave the spirit today, if that came up. Well, what about that being the case with artificial intelligence? The artificial intelligence would own the copyright in the music it had just composed. But of course, when it comes to the term of copyright, life of the author plus 50 or 70 years, well, of course, the artificial intelligence is not alive any more than the spirit was. So I guess we'd have to say something like 50 years from creation might be the term of copyright. Okay, well, that's it. Any questions? Well, I can play some music to...
Ken, Matt here, mate. Hey, just in preparing this and in other work, have you by chance been able to ascertain where MB's at with the copyright review, if at all? If they've progressed that at all in the last sort of quarter before this COVID-19 crisis?
No, they were, as far as I understand it, they were just still putting together their big compilation of all of the submissions and sort of writing a comparison of different submissions and then coming up, well, you know, this sort of suggests that we should have a provision that does this or that. And they're still, yeah, as far as I know, they're a long way from completing that. And of course, when that does come out, we'll be able to have another chance to make submissions on that. But no, things seem to have been going slow even before the COVID virus. Well, as Winston Peters once said to me many years ago, when I was urging some copyright reform back in 1985, we did actually get some, but he said, Mr. Moon, there are no votes in intellectual property law, so the government will have to have a lot of time on its hands before you think about those things.
Thanks, Ken. Does anyone else have any questions at this stage? No, we're all good. Hey, Ken, thank you so much. Sorry.
I was just going to say, if I click the little sound icon there, this is an advertisement for my next seminar next week on the music infringement case, Led Zeppelin being sued in the USA. And it's for their song Stairway to Heaven, which is, we're hearing the first few bars of it now. So no one needs to listen to it through. That's just my advertisement for next week.
Awesome. Thank you, Ken. Thanks everyone for tuning in. Ken, we really appreciate you doing this under the circumstances and look forward to your one next week. We had 43 participants today, so that's fantastic. Everyone, Alex will be able to make a note that you've attended this, and there'll be a CPD record sheet that I'll sign off on that as well. So 45 minutes. Well done, everyone. And thank you, Ken. Cheers. Hope everyone's well.
Thanks, Ken.